Hey folks, Jim Wallace here from Gun Owners Action League, Executive Director, and I'm with...
Mike Harris, Director of Public Policy for Gun Owners Action League.
And we are, well, not live, but we're in the Hornady studio
Yes.
anyway. Someday we'll be live. We're getting there. That'll happen hopefully pretty soon. So, and then you'll be sick of us and want to shut us off. But that's all right.
Hence the new microphones and all that
Yeah,
stuff.
I know. This is like fancy. I don't know. I'm an old crusty guy, and look, I don't know. I'm not sure how to take this.
We're working on it.
Yeah.
We're upping our production quality.
Well, my first tablet had a hammer and chisel, so, there's that. Anyway, folks, thought we would talk a little bit about the great disappointment from the United States Supreme Court with two cases. So we had, Ocean State and Snope?
Yeah, Ocean State Tactical v. Rhode Island and Snope v. Brown.
Yeah, it's a shame because one of the reasons that Goal had not filed an assault-style firearms lawsuit here in Mass is because there was already one at the very steps of the Supreme Court. And it looks like, once again, they've caved. Yeah. They're not going to take it up. So we're going to have to shift gears a little bit here because who knows what cases may come up because there were two different ones, one dealing with basically the magazines.
Yep.
And that was Ocean State
Ocean State Tactical,
right.
Yeah.
And Snope was pretty much the assault weapons issue. So we're going to have to figure out how we're going to move forward now. And we are going to move forward. We're going to end up filing a case, hopefully in the next couple of months once we develop what we want to do and how exactly we want to attack this. But
Yeah, I mean, I know SAF has about 7 different cases pending right now. There's the Bonta case out of California challenging their assault weapons ban. That's a big one. And I think it's high time for us to jump on that battlefield.
Yeah, we did it once, and the exact same thing happened back in 2016 when Maura Healey lost her mind and created law via press conference. Thanks to the great financial help of the National Rifle Association, we spent 2 years bringing that all the way up through the federal court system and got to the United States Supreme Court only to have them do the same thing to us. They just wouldn't take it. And frankly, that's, Mike, I've been saying for a long time. It's all these keyboard commandos that during the fight of 4420 in the State House, how many times did we hear, stop all this nonsense and just file a lawsuit? And we warned everybody, if it happens, if this thing becomes law, we're going to go after them in court. But even if we do, it could take years and years and who knows how much money.
Millions of dollars.
A single case could be millions of dollars. So hopefully those people that kept saying that during the fight will get out their huge checkbooks and now start paying for the lawsuits they so wanted. Yeah. And if you can tell, I'm a little bit irritated about that stuff. So for all the people that actually fought with us, and literally, I got to say, they were heroes because I know it ended up being passed, but we stopped the Speaker of the House dead in his tracks for 2 months.
2 months.
And then they had to go secret.
Yeah.
They wouldn't even let us see the language.
And they barely changed it when they came back with the new version, too. That was the funniest part of it.
Yeah. Call it the 24 hours. Isn't there a show about that? 24 hours?
The first 48.
First 48? Okay. Well, this is half of that. So. Yeah. So anyway, there's some interesting things in the law here that may make the case even more interesting nationally because even though Goal does not believe what the state is trying to push, so far the Firearms Control Advisory Board is advising or trying to advise the state that there's 3 different dates.
Yeah. 3 different grandfathering dates for assault-style firearms. There's the 1994 pre-ban date that would allow you to put whatever scary features you want to on your rifle, and then there's Maura's made-up July 2016 date where where the term legally possessed before 8/1 comes into play. So if you didn't have your AR or your AK or your copies and dupes before July 2016, they weren't legally possessed prior to 8/1.
Don't forget my favorite, the Street Sweeper with the Rotary
The
magazine.
Rotary magazine. Those are cool, though.
Do you know, back when Maura Healey was pulling her garbage, before she actually did that, I actually met with her staff, and we were talking about so-called assault weapons. This is how much experience these people have.
Yeah.
He said, all you had to do is pull that trigger, and all those rounds went off at the same time. And I said, wow. Everybody's going to call you righty. And he says, what are you talking about? I said, where's your left hand when you're holding a shotgun like that? So you're talking, anybody that shot that gun lost their left arm. And it's
With the recoil like that, also your right arm.
Well, that's true. Yeah, well, that would be dislocated. There would certainly be some, what do they call it, rotator cuff surgery going on?
8 shotgun shells going off at once.
Man, it's bad enough.
Laying down.
I used to have a 10 gauge. Fire that was bad enough. But anyway, so there's some interesting things. To us, August 1st is now the date. And the reason Mike and I have talked about this
Endlessly
is if you look at the new law, the 1994 date as it pertains to the gun is gone.
It's not in there at all. It's not mentioned It's not mentioned regarding firearms at all.
You see, in the definition, people get a little confused because it shows up, but only as it relates to the old Appendix B in the old federal assault weapons ban. So, but it doesn't show up as far as owning it prior to that date. Now, the key, we believe, is that it does show up when they discuss the magazines.
Right.
And to us, or basically to the legal world, that should show intent.
I agree. Yeah. I mean, if you're going to get specific about one aspect of the law and leave it out completely in another, it shows intent. Exactly. I mean, they meant to leave that date out of there. And I don't know if that intention on their part was to get rid of your ability to have scary features on your pre-ban assault weapon.
Right.
Or if it was to just not have it in there just for the hell of it. But
it was always the push as it went to the Senate to have the August 1st date be the new grandfathering
for
date.
everything.
And the 2016 date didn't even show up until Cynthia Cream, threw a wrench in the gears and suddenly threw that in. But here's the interesting part. Again, the discussions we've had. The 2016 date, in my view, not being an attorney, don't play one on TV, thank God. It refers to a law that no longer exists.
Right.
In other words, the Attorney General's guidance letter or enforcement letter, to me, is moot now because it refers to a law that no longer exists. Mm-hmm. So to us, the August 1st date is the date. And I think that's what we will be pushing as we move forward. Now, we certainly want to get rid of everything. We don't believe there should be any of this stuff in place, period, because they're just rifles and shotguns and handguns. There's nothing special about them other than an evil term that every town made up.
Well, it's it's an invented political term that means whatever they want it to mean at the moment they're talking about it.
I mean, even in the military, we didn't use the term assault weapon. No. It was a rifle.
Well, it wasn't made up yet, Joe.
Well, that's true. Yeah. Well, no. Well, I don't know. So I'm not that old for crying out loud. But it's kind of interesting. I wonder what the lineage is. How long after the AR-15 became into public hands in 1958 versus the term assault weapon? I think it's like 30 years.
Probably at least.
So apparently it had to really mature as a gun to become an assault weapon. So, there's all that discussion.
Well, nobody wanted it yet because it didn't have any wood on it yet.
There you go. There you go. So, and my favorite group, Moms Demand Attention, always loves those terms that they can easily use and not understand. Mm-hmm. Matter of fact, I was in a discussion with one of them one time, and I asked her, I says, so we can have this discussion. So we're on the same page. Can you tell me what an assault weapon actually is? She refused to talk to me anymore. She goes, I know what you're doing. Really? All I'm asking is that we're on the same page so we can have that. Nope, wouldn't even do it.
Hey, give me a definition so we can both be talking about the same thing.
Yeah. Yep.
Yeah.
Nope.
It's
as
a
long as it's
political term.
scary, we don't like it. That's
it's a
what it's
political
all
term.
about. So anyway, we're going to move forward with that case. We also are still working on putting together a case going after the entire licensing scheme. As gosh, how many? I can't even tell you how many reports we're having about delays. Licensing issues, and
some of them are from towns that we didn't expect.
right.
Which is the wild thing.
Well, I think some of that is budget because even years and years ago, it was always, even the chiefs would say, this is an unfunded mandate. I don't have the manpower for this.
Well, that's on purpose.
So, it's bound to happen. So anyway, we're trying to go at it not as issue this person their license. We're trying to go at it as a systemic violation of civil rights, a denial, as Mike calls it. That if it's a delay,
it's essentially a denial, depending on how long your delay is sometimes. But yeah.
Well, look at what you talk about, the non-resident.
I mean, I've had arguments with a couple of lawyers about this, and I've gotten some disagreement on it. But I think if you're applying for your temporary LTC, which is good for a year, and you are delayed a full 365 days, even if you're issued it at the end of that, that is effectively a denial. I applied for my license for this year, not for next year. And I know there's constitutional issues with, your right to work and your right to do certain jobs, but at the same time, if you're denying somebody their ability to go to Massachusetts to do training or to teach or something like that, you're also, you're screwing with their livelihood at the same time as keeping them from being able to protect themselves and then,
Well, especially in that instance, because we advise people who don't live here, don't come in the state with a gun, period, unless you have that license
unless you
now.
have a temporary LTC.
Because most of the all of the exemptions are gone.
Yeah.
I even had that discussion at FCAB, and I was told, no, in 129C, there's the exemption that if you're under the supervision of a licensed individual at a range, and I said, yeah, okay, how'd you get your gun to that range?
Yeah.
And I get blank stares. So
because FOPA doesn't protect you unless you're going through the place that you're not authorized to carry.
Even mass law now
Yeah.
says you're fine if you're traveling through, but not if you're going to a destination in Massachusetts, whether you're going for competition, training.
Or even if you have to stop incidentally. If you stop for a cup of coffee on the side of on like a Dunkin' Donuts, even if you're driving through, you have to take your gun off, put it into a locked container in accordance with FOPA before you can even get out of the car to go to like a Dunkin' Donuts or something like that.
Yeah,
So
it's crazy.
there's a lot to it.
There's other cases happening. Now, we're still not sure what the heck to do with the long gun situation because we had paid the money to prepare a federal case against the long gun testing and the roster situation. And we announced that we were filing it. We were all ready. And that's when the state said, well, hold on. We're not sure we're going to do this. Well, the problem is we've been told the Secretary of Public Safety is on board with the FCAB's recommendations that it just isn't going to work for long guns. The testing was designed for pistols. The roster's designed for pistols. So this stuff ain't going to work for rifles and shotguns.
Right.
Although I have said all the
frames.
time that I would love to see somebody drop test a bolt-action .458 Magnum because I think that would just be something else to watch.
Even just drop test your basic 12 gauge for God's sake.
Yeah, we could find some volunteers for that too, I'm sure.
Sure.
So the problem is the FCAB wrote a memo to the Secretary of Public Safety. Through his attorney, we were told, yep, they're on board, they're not going to do it. But there has not been any official guidance from the Secretary. And I'm not even sure if that's defensible, but at least we have guidance that we could take to court if somebody gets in trouble.
Yeah.
So the FCAB, which unfortunately I sit on, it's not a great experience, Mike, that is only advisory.
Right.
Now, the interesting thing is, if you look at what's not being done now with this, when was our last guidance? Official guidance?
Oh my God, like December?
November.
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 Yeah, November. Oof.
So I have wrote and talked about the last couple of months, I don't think we're going to see anymore. Because every time they issue guidance, they're weakening their law.
Yeah, and also on top of them weakening the law substantively, they're also taking away the ambiguity, which I argue all the time. We've lived in this like weird gray state of ambiguity since 2016, and I think that is kind of ambiguousness is a deterrent.
Yeah.
In some circumstances, because if you don't know what you're not supposed to do, you don't know what you're not supposed to do.
I can't tell you how many interviews I did with the media about that when they would, remember when they were on this huge thing? It was around when the mill was being attacked by the Boston Globe. And all kinds of media would ask me, well, why hasn't the Attorney General at that time, Maura Healey, actually enforced the law and prosecuted people? And my statement then, and it turns out to be the truth now, is what's more politically powerful, prosecuting a handful of people or keeping hundreds of thousands of people scared?
In the dark. Yep.
In the dark. Scared because they don't know what the law is. And at any time you could be facing 50 years in prison. And I know a lot of people who say, I just won't comply. Okay, but tell me that when you're being charged with 5 felonies and you're looking at 50 years in prison and you're begging somebody to get you out of it.
It's tough.
It's tough talk. And while I agree with you or agree with the sentiment, it's not realistic for the average family out there.
Yeah,
so we need to get answers, and they don't want to give them.
No, and they're not going to. I'm like you said, I'm sure they're not going to.
Yeah.
And who knows what the next, administration is going to do with any of this stuff.
I have no idea. But that's why even at 16, I coined the phrase felons in waiting.
Yeah.
We're all felons in waiting at this point. We're doing the best we can, but that also makes it difficult to file cases. Because if the state can't even tell you what it's doing, then what are you arguing in court? And to some extent, I believe that's why they've also, every time we filed a case, suspended a portion of the law.
Yeah.
Because they don't want to defend it in court.
Yeah, I mean, Jay our attorney likes to call those little victories. And he's not wrong. I mean, we are affecting what the state is doing. But at the same time, we're not looking for a delay. We're looking for the fight.
Yeah, that's like going to a Boston concert and parking is $500,000 and you went to see the concert. But,
yeah.
And
it's also like one of those things. It's also pretty scary to see how quickly the legislature can move in response to this stuff. That's the part that freaks me out the most.
Well, look at how fast they passed it.
That's what I mean.
Yeah.
Yeah, I mean, it's
the whole bill.
Oh, well, that was just irresponsibility, honestly. Yeah. I mean, they released the final version of the bill at 8:00 at night, the night before they're supposed to take the vote at 1 p.m. the next day. I mean, that's just irresponsible.
Yep. Well, they had to. They had to do it in the shadows because if they gave the public time, it is what it is. So anyway, folks, it's just a little bit of update on everything that's going on, especially in the courts. So I'm sure we'll be back talking to you soon. And Mike says we're going to be live at some point here.
Yeah, I'm getting the handle on how all this stuff works. We got some new gear. And
there's some stuff here that I just don't understand. So I'm going to leave it to the younger crowd. And I'm going to go back to my hammer and chisel and write.
I just give you a set of headphones and stick a microphone
That's
in front
all.
of you. Let's let you talk.
That's all. It's funny because we used to have a public access cable TV show in the Berkshires. And we had an older board member, Pete McBride, who was an engineer. So I tried doing a show with an engineer. Because he wanted the whole show plotted out. What are we going to say? I'm going to ask this. I would tell him, Pete, ask me 2 questions. I can fill a half hour.
We'll do it. We'll
Don't
just go from there.
you worry about it. So, but anyway, folks, again, Jim Wallace here, Executive Director of Goal, and
Mike Harris, Director of Public Policy.
We'll see you next time.
Yep, thanks.